Your Honour, if it pleases the Court, my name is Emily Armitage and I represent Mr. Ike. Today I will be requesting a ruling under Section 590AA, subsection E of the Criminal Code to exclude 3 pieces of Crown evidence. The Court has the discretion to exclude pieces of evidence in criminal proceedings under Section 130 of the Evidence Act, Queensland. The first 2 pieces of evidence should be excluded as they were improperly obtained by police, and the third due to irrelevancy. I'll touch on the first 2 pieces of evidence together, and they are as follows. Firstly, the oral testimony and any written documentation from the arresting officers in regards to my client's admissions made to them in the police vehicle regarding the 84 properties shown to him. And secondly, the recording of the police interview where my client officially confesses. I submit, Your Honour, that these pieces of evidence should be excluded in the interests of justice under the public policy discretion or the unfairness discretion. The public policy discretion was derived from the Crown against Ireland and expanded upon in Bunnings and Cross, where the High Court weighed 5 factors. They are as follows. Firstly, whether the conduct of the police officers resulted from genuine mistake or deliberate breach of law. Secondly, where there was deliberate breach, whether the evidence is vital to the Crown. Thirdly, whether the police were acting out of necessity. Fourthly, the gravity of the offence. And finally, the 5th element, whether the conduct breached a statute. These elements require in-depth consideration of the conduct of the police officers, and as such it is more cogent to deal with element 5 first, as it asks us, did the conduct breach a statute? The first admissions made by my client to the police officers in the police vehicle were made without the opportunity to talk to a parent, lawyer or support person, nor with anyone other than the officers present. As Mr. Ike is a 14-year-old child, Section 421 of the Police Powers and Responsibilities Act, here in the PPRA, requires that a support person be present. The officers were aware of his youth as they referred to him as young fella. Furthermore, Mr. Ike is a Torres Strait Islander, and as such, guidance for proper procedure should be taken from Section 420, which also requires that a support person be present. Section 431 requires that the officers caution my client of his right to remain silent, which they failed to do so before questioning him. Furthermore, in breach of Section 436 of the PPRA, no record of the confessions was made, despite the fact that the police officers had ample time to do so, as they had time to drive my client to 84 different properties. This breach in and of itself is grounds for declaring this piece of evidence inadmissible, as Section 436, subsection 3, says that a confession will only be admissible if it is recorded. The conduct of the officers in the official interview also breached several sections of the PPRA. Although Mr. Ike finally received a support person, this was not a person of his choosing, which breaches Section 421, subsection 2A of the PPRA. Furthermore, the officers failed to provide sufficient time for this support person to talk with my client prior to the commencement of the interview. During the brief moments alone with this support person and during the official interview, my client acquiesced to the questions of the police officers. He avoided eye contact and he showed clear signs of being extremely uncomfortable. These are all hallmarks of gratuitous concurrence. It was the support person's responsibility to support my client in understanding any cultural differences. They failed to do this. The police should have recognised this failure and excluded this support person under Section 427 and Section 428, subsection 2, and given my client a different support person. Additionally, the confession tape was incorrectly recorded, with several inaudible periods. Anything could have occurred during these periods, including coercion of my client, as he was in a very vulnerable and distressed state. The conduct of these officers shows blatant disregard for the law set out in the PPRA, and therefore satisfies element 5 in favour of exercising the discretion to exclude this piece of evidence. Moving on to the other elements now, we start with element 1, the conduct of the officers, which was clearly a deliberate breach of law, as there were numerous opportunities for the police officers to abide by correct procedure when they failed to do so. This conduct seriously impacted my client, who is a very vulnerable member of society due to his youth and his Indigenous heritage. In regards to element 2, whilst this evidence may be vital to the Crown case, the cogency is in severe doubt. My client's Torres Strait Islander descent contributed to a confession brought about due to gratuitous concurrence, not any guilt on the part of my client. The confessions therefore lack probative value. In regards to element 3, there is no evidence at all that the police were responding to pressing circumstances. Considering element 4, my client's charges, whilst they are not trivial, they did not impact the life or safety of anyone else, and they did not involve violence, therefore indicating that they do not warrant their evidence remain admissible on those grounds. On balance, these elements favour the exercise of the discretion to exclude these two pieces of evidence. Such deplorable police conduct should not be condoned. Alongside the public policy argument, the conduct also merits exclusion under the unfairness discretion. This discretion, derived from the Crown against Christie, is founded on the principle that some pieces of evidence may be highly prejudicial to the accused. In Hasler, it was discussed that the probative value of the evidence must be outweighed by this prejudicial effect. It is my argument that the confessions of my client are minimally probative, as they were the result of gratuitous concurrence, and are highly prejudicial, as they contained affirmations of guilt which were misleading. Therefore, they merit exclusion. There is one final piece of evidence that I believe should be excluded due to lack of relevance. This is the testimony of my client regarding the initial discourse with police, where he admitted that the items in his bag were not his own. This admission purely by itself is not relevant, as it is equivocal. This principle was proven in BVH against the Queen. The admission that the items were not his does not rationally affect the issue as to whether items were stolen from the house. He may have simply borrowed the items from friends or family, or came across them in a variety of other ways. Therefore, the statement is equivocal. The state has admitted no other evidence which provides context to the statement. Therefore, by itself, it is irrelevant. Your Honour, on these grounds, I request that you exercise your discretion to exclude the three pieces of evidence I have outlined above. Thank you.